For judgment, item 1 and 2.
Yes. This is WPC 94 of 2024 with WPC 99 of 2024, wherein this court finds it appropriate to dispose both the writ petitions in a common judgment in order. Now, having considered the submissions made by the learned counsels for both the parties, this court finds that the respondents' authority had erred in passing the impugned notification dated 23/07/2024 without taking into consideration the promotion which was under the criteria of seniority cum merit. Okay. And accordingly, the impugned orders stands squashed and cancelling the promotion of the private respondents. Yes. So the writ petitions stand allowed and disposed of. Yes.
Obliged.
Basic Lordship indulgence in making a mention in respect of item number 2 and 3 of part 2 hearing list, my lord. In this case, my lord, I'm for the petitioner and Mr. L.S. Lianshima, senior counsel is for the respondents. And
2 and 3, yes.
yes, my lord.
2 and 3.
We propose that this matter may be referred to mediation, for mediation. The ongoing
For mediation,
Yes,
both
my
the
lord.
parties?
Yes, my lord.
Fine.
Okay. Mr. Victor L. Rante, learned counsel for the petitioner, is present along with Mr. L.H. Lianshima, learned senior counsel for the respondents. The learned counsels for both the parties submit that the matter may be referred for settlement through mediation, since both the parties are willing to come to try and settle their dispute amicably. So accordingly, matter to be referred for mediation, the High Court Legal Services Committee to take necessary action. Yes.
And my lord, similar prayer in respect of item number 5. Here also we both are representing the respondents and petitioner appellants.
Then same order? Same order?
Yes, my lord. Deeply
Okay.
obliged.
Number 5 also. Yes.
Yeah, please, Lordship, my lord, I would like to take your lordship's indulgence in making a mention with regard to part 2, item number 4. Yes, the
Yes,
matter may be
4.
taken up after 2 weeks.
Have you taken the consent?
My lord, yes, I inform and taken.
Okay. But Mr. William Kroner, learned counsel for the petitioner, who has prayed for adjournment of the matter with the consent from the other side. In view of the above, as prayed for, list after 2 weeks.
Much obliged.
Seek Lordship's indulgence in respect of item 8 of part 2. If this matter may be taken up after 2 weeks, Your Lordship. My learned friend, Mr.
Both of you, you're there?
Yes, Your Lordship. I have no objection, ma'am.
Okay, then we'll just make it on the submissions made by the learned counsels for both the parties. List after 2 weeks.
I'm deeply obliged.
Motion item 3.
Yes,
Good morning, my lord.
yes.
My lord, this is the matter which had come up day before yesterday in the admission list. And my lord was the opinion that it should be put in the correct list. So it has been refixed today for motion. My lord, I'll not take much time. My lord, this is the same matters which we had moved on the 4th of August, my lord. We had not received the judgment in respect of this matter, so we could not have moved it. My lord, the same question of law is involved in this matter also, my lord, where we have challenged the judgment, my lord, dated 5/10/2023, Annexure 1, page 27 to page 50, my lord, wherein again the Deputy Commissioner has been delegated the power by the learned district judge to do the quantum of assessment when under section 16(3) of the Telegraph Act, it is
Okay, for
only
the
the district judge who...
additional quantum, is it? Additional amount.
my lord, the additional amount, my lord.
Okay, now in your synopsis, it's also mentioned
My lord.
that the guidelines 2015 has been referred to, which was
My lord.
adopted. So is this also one of your points?
My lord,
In
it
your
is one of my
synopsis, or
points.
you're going to not press that matter? That point?
My lord, I will, that will also be one of the legs of my argument when
huh.
I argue, but primarily I am coming under the point of law here.
Okay, 16.3.
16(3), my lord.
Yes. Okay, we'll issue notice. Heard
My lord.
Mr. Nkera, learned counsel for the petitioner, who has filed the instant civil revision petition under Article 227 of the Constitution of India, challenging the judgment and the judgment passed by the additional districts and sessions judge, come judge fast track court, Colosseum district in civil application number 3 of 2018, dated 05/10/2023, where in the learned trial court had exceeded its jurisdiction by delegating the power to determine the compensation to the district collector. Which is contrary to section 16 within brackets 3 of the Indian Telegraph Act, 1885. Claiming additional compensation.
My lord, enhanced compensation.
Additional compensation, enhance whatever, isn't it? From the
My lord.
against the construction of 400 kV DC Silchar, Assam to Melriyat transmission line, which is passing over the lands of the respondent number 1. Issue notice of motion to the respondents. Mr. Samuel L. Changte accepts notice on behalf of respondent number
2, Mala. There are only 2 respondents.
2.
Yes, Mala. The district collector.
Okay, so you're as the additional AG.
Yes, ma'am.
Okay, learned additional AG accepts notice on behalf of respondent number 2. Notice be issued to respondent number 1 through registered mode within 3 working days, returnable by 3 weeks. List after 3 weeks. Yes.
Obliged.
My lord, in the interim, the judgment and the verification notice we state, my lord, as it has been done in the other matters. Verification notice is at Annexure 7, page 129, my lord.
Meanwhile, as prayed for by the learned counsel for the petitioner, the verification notice dated 30/04/2025 shall remain stayed till the next date of listing. Yes.
Obliged, my.
Item 4.
My lord, permitted to leave.
Yes, yes.
Obliged, my.
Yes.
Yes, my lord, this is the second round of the writ petition. The previous writ petition was disposed on 28/7/2025, passed in WPC 71 of 25, whereby the respondent was instructed to dispose the representation dated 28/2/25, and the respondent have disposed of, however, declining my claim on the ground of lapse of about 16 years from dismissal from my service.
How many years?
16 years.
16 years?
Yeah.
So why did you take so much time? Why was there such a long delay?
My lord, it's because of my financial constraint and legal advices that I could not be able to engage.
So now you're financially sound or what?
No,
that
my
you
lord,
can,
no.
Finally engage after 16 years.
No, my lord.
Anyway, we'll have a look. So where's the order of this court page?
It is in page number 62, Annex 18, that was disposed by this honorable court.
62.
Yeah. 46. Sorry, my lord. 46.
Oh, it was this court that had passed the order, huh? It was passed on 27/06/2025, and the matter was considered when? On which date?
On 28th July. That is in,
Within 3 weeks.
yeah.
So where's the impugned order?
62, my lord. Page number 62. Annex 18.
English translation is 64.
Translation, yeah, in 64.
Okay, we'll issue notice, but you have to give a good reason, isn't it? Anyways, heard Mr.
Simon Asylum.
Assigning Thang Asylum, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for issuance of the appropriate writ or direction to the respondents, being agreed with the order dated 28/07/2025, passed by the respondent authority who have rejected his prayer for compassionate allowance on his dismissal or removal from service. Okay, under which provision of the law?
Rule 41 of CCS Pension
Okay,
Rules 2021.
Under Rule 41, within brackets 1, close bracket, then again within brackets 2, then close bracket 4, close bracket, and 5 of the CCS within brackets pension rule, close bracket, 1972. On the ground that the claim for compassionate allowance was made after a lapse of 16 years from the date of his dismissal. Dismissal from what? Dismissal from which this thing? From the
Second IR battalion.
second
IR battalion.
IR,
Khosol.
is it?
Yes.
IR battalion. You see, when you read here, this thing, it's very vague, battalion, okay, full stop. Issue notice to the respondents. Mrs. Caroline K. Moipui, learned government advocate, accepts notice on behalf of the state respondents. Anyone else? No need to issue formal notice. Requisite copies of the writ petition to be duly furnished to your learned government advocate. List after 3 weeks.
Obliged.
Admission, item 5.
Yes.
Please, Your Lordship. In the last court date, there's a writ appeal disposed that writ appeal number 1 of 2023. Lordship, we got it the last time I've given you.
So,
If not,
did you get
I
the
can-
proper instructions? Are you going to file
Your
any counter
Lordship.
affidavit?
Your Lordship, I've gathered verbal instructions saying that this stretch of land, which is regarding the award number 3 of 2014, it is going to be challenged and appeal will be filed, Your Lordship, in this regard. So,
Anyway, so what you can do is you can pray for time
yes, Your
to
Lordship.
file your counter affidavit. Okay. And then in the meantime, in the next date, let's see if it is.
Your Lordship, in this
If there's
case,
an
they
appeal.
have already filed counter
You have?
additional 3 affidavit they have already filed. It's pending for quite a long time, that's right.
So we'll give them one more chance, see if you, so you're preferring an appeal, is it, against the,
Judgment of the lower court, Your Lordship,
No,
which
Your Lordship,
pertains
the
to...
judgment, if you read the judgment
judgment?
properly, it says that
which judgment? This is a WPC?
writ appeal.
But,
Oh,
Your
you're going to
Lordship,
prefer an appeal against?
Yes,
the
it
writ-
No,
was
Your Lordship.
dismissed. And
Wait, let her this thing, how,
Your Lordship,
appeal against what?
there was a judgment of the additional district and session judge in the district court, which pertains to the same stretch of land.
this is,
And so it pertains to the same award, number 3 of 2014. It might not pertain to the similar writ petition, however, the
This is a
same
writ
stretch of
petition,
land.
That's why you're going to prefer an appeal against what?
The appeal is going to be filed against the judgment of the district and session judge. And
Is
regarding...
the writ petition arising out of the judgment of the district and session judge?
no.
No,
it-
then?
No, Your
It's
Lordship, but
mixed
it is the same stretch of land, it is the same award.
Petitioners are the same award. I
The
don't
award is of
understand.
number 3 of 2014, Your Lordship. So it is the same stretch of land and also the same award which has been challenged in the district court, and the final decision was made in December 2024. Your Lordship, that is why at this
There's
stage,
another connected writ petition also, which was disposed of in favor of the petitioners, and then it went on appeal. That's the same award. The instant writ appeal,
yes, Your Lordship.
it's an appeal against an order of this court regarding the same stretch of land, same award.
Yes, Your Lordship.
So how big
Therefore, Your
pieces-
Lordship, that is as per my verbal instructions so far. So that is why,
Anyway, counter affidavits have been filed,
yes, Your Lordship.
pleadings complete, then
Yes.
we'll consider in the admission hearing properly. Okay.
Yes,
But
it's a mix-up,
yes,
I
see if
think.
you're making sense. Okay.
Your Lordship, it is of the same award, Your Lordship. I am not mixed up.
Same award.
Same award.
Same award.
And I am just informing the court, Your Lordship, regarding
But the judgment of the the reference court, is it? Or
Yes,
the
Your Lordship.
district and sessions court, sessions judge? We'll have to produce that and see whether the instant writ, because I'm saying this because in the writ petition, a connected writ petition,
Yes, Your Lordship.
against which there was an appeal, and the appeal has been set aside. It concerns the same stretch of land. Maybe the parties are different.
Yes, Your Lordship.
So the award, it appears, just prima facie, it appears
Yes, Your Lordship.
that the said draft award has been approved. It's not been, so when the draft award itself has been confirmed in the writ appeal, then what's this judgment of the district concession judge concerning the writ appeal? Then won't there be some confusion as to which judgment are you going to rely upon?
Yes, Your Lordship, that is the very reason why I'm asking for more time, so that there is no
Come prepared
Yes,
the
Your
next
Lordship.
court date and get the copy maybe of the judgment which you're going to prefer an appeal.
Yes, Your Lordship.
Okay, then we'll look at another writ petition which was disposed of. Because if it comes up from this of the same award, then is it possible? Just trying to figure out.
Yes, Your Lordship. Those are the reasons why I'm requesting that time may be given, Your Lordship.
Okay, when was this judgment passed? Judgment of the district and session?
17/12/2024, Your Lordship, as per my verbal instructions.
Anyway, we'll give you time. And then we'll have to look at the writ appeal also, because the way the writ appeal was disposed of, whether it actually touches the case or not also.
Yes, Your
Quite
Lordship.
interesting. Read this thing, judgment in the writ appeal also. Whether it will be binding for this writ petition. Anyways, Mrs. Denari, learned counsel for the petitioner, is present along with Ms. Lal Nunpui, learned government advocate for the state respondents. The learned government advocate has prayed for adjournment of the matter by submitting that he needs time to get proper instructions in the matter, since she has been verbally informed that a judgment of the additional district court concerning the same award passed on when?
17/12/2024, Your Lordship.
17
17/12/2024.
12/2024 is likely to be appealed against, and it could affect the instant writ petition, since the instant writ petition is also with regards to the same draft award within the same stretch of land. Yes, in view of the above, list the matter after 1 week.
You can fix the date, Your Lordship.
Yes,
If it may be fixed in the second week of September, Your Lordship.
Your Lordship, see, the WA also disposed in October 2024. This court is directed that waiting for the judgment of the WA. So now,
copy has been given to the.
yeah,
Okay,
their
yes,
appeal,
Yes, okay.
their
fine.
appeal.
So
And
anyways,
because
list all.
maybe they have engaged a private lawyer in this regard appeal. So there must be some miscommunication
So
also.
let's, first week of September,
Yes.
list on, let's make it second.
Your Lordship, if the matter may be listed on the 5th or the 8th of September, Your Lordship, because I already have a fixed matter on the 2nd as well.
Okay, on 5th, 9/2025. Yes,
So, Your Lordship, just observation may be given. No more adjournment because we are waiting for so long.
let's see what happens on that day. Okay, yes.
Much obliged, Your Lordship.
Item 6,
Lordship, I'm appearing on behalf of my senior CGC for respondent number 6. May I seek another 3 weeks' time for filing our counter affidavit?
Your Lordship, I'm appearing on behalf of the state respondents. We've already filed a counter affidavit in the month of February 2025.
Yes, so CGC, respondent number
6.
6. How long are you going to take? How many adjournment has been paid for?
Lordship, respondent number 6 is newly implemented respondent.
Okay. Yes. Mr. J. Malsomzwala Bantam, learned counsel for the petitioner is present, along with Miss Baby so-and-so, appearing on behalf of her senior, Miss Zairem Sampui, learned CGC for respondent number 6, and Miss Lalnun Nui, learned government advocate for the state respondents number 1 to 5. It is submitted by the learned government advocate that they have filed their counter affidavit, while the learned counsel for respondent number 1 to 5 have prayed for further time to file their counter affidavit. In view of the above, list after 3 weeks.
Yes, my lord.
Item 7.
My lord, in this matter, I am for the respondent number 1 claimant. My lord, and this matter is one of the cases which have been identified for referring to mediation, my lord. And subsequent to that, I have taken instructions from my client, my lord, and they are willing to send the matter for mediation, my lord.
Who is the appellant? The insurance company?
Yes, my lord. SBI.
So insurance company,
Lordship, yes, we are also willing to take the matter to mediation.
you are not willing.
No, we are willing.
You are willing.
Yes, ma'am.
Okay, what is the appeal about?
The appeal is that we are aggrieved of the award made by the MSCT that we have to pay the claimant rupees 44 lakhs, my lord.
So you are saying that
Mainly
you are
on
not liable to pay the compensation, is it?
Yes, my lord. We appeal that. We challenge the appeal. Sorry, my lord.
You challenge the appeal.
No.
It's mainly on the quantum, my
are you
lord.
Yes, my
appealing?
lord.
On the quantum,
Yeah.
is it?
Yes, my lord.
So if it's just on the quantum and the insurance company accepts the fact that you are liable to pay the compensation amount,
Yes, my lord.
then I think you can come to some settlement, isn't it? So we'll refer it. Let's see your ground of appeal. Because it appears that the owner and the driver of the vehicle are not represented.
Yes, my
But
lord.
if
We
you
have
can
also filed the
settle the
affidavit.
matter between
incorporating
the
same.
insurance company and the claimant, it's well and good. Mr.
Lomo Maralte.
Lomo Maharalte, learned counsel for the appellant is present along with Ms. C. Tlantiang Lima, learned counsel for respondent
Number 1.
number 1 / claimant. The learned counsels submit that they are willing to have the matter referred to mediation for to make an attempt to come to an amicable settlement. So, in view of the above, release the matter for mediation and the High Court Legal Services Committee to take necessary steps. Yes.
Obliged.
Yes, my lord.
Orders, item 8.
Yes.
Your Lordship, TCR has arrived. And however, in the meantime, we are proposing that whether this matter should be sent to Lok Adalat for an
Lok
attempt to.
Adalat or mediation? The only
Lok Ad-
difference between Lok Adalat and mediation
Hmm.
is that in mediation, you have a trained mediator.
Yes.
So it's one person, a mediator, and he will try and counsel with both the parties so that they come to some settlement. Okay. And the other difference is the parties, if they happen to settle the matter, then they are relieved of the burden of having to come to the court every time or
Yes.
through their counsel. The matter is settled. And because of that, they have to pay the mediator a minimum amount of fees. Okay, they have to bear that. It's around a total of 5,000, but it's still worth it. And mediation, it's good in a way because we have the trained mediators who have undergone 40 hours training,
Yes.
isn't it? So,
My lord, we are proposing that whether it would be better to send it to Lok Adalat because it's a very simple matter.
simple matter,
Yes.
then all the better for the mediator, isn't it?
And if possible, what we are further proposing is that, with your lordship's permission, if possible, to hold the Lok Adalat proceeding there in Siaha district, because all the
Okay,
parties are,
Siaha.
all the parties are staying in Siaha.
But at Siha also, you still have the district mediation center. It's the same thing actually.
Yes. So at least it could be done in Siaha district then, my lord.
Okay. What is the dispute
The
concerning?
dispute is, my lord, this is regarding the dispute between the, in respect of the land between the church, Iso Krista Koran.
Okay.
And land lease was declared as, the ownership was given to the respondent number 1 church, that is Iso Krista Koran, while that is the land lease only. So Mara Autonomous District Council, feeling aggrieved with this, we have filed this appeal. Because in lease, the condition of lease deed, that land lease certificate doesn't authorize any ownership.
Okay, so you want ownership, not
Yes,
lease.
yes. We are leasing out the land only, my lord, by the MADC. So they cannot be given by the court the ownership and right over the land.
Okay, you are the. So lease for how many years?
Lease is, my lord. I'll just come to the,
10 years, 99 years, how many years?
yes, my lord, it is for 20 years, my lord.
20 years. From which date?
Sorry. 2009, my lord.
So, 19th, okay. So ultimately are you planning to take the landed property back or what?
That will be depending upon whether they could still,
20 years?
yes. I don't know whether they would be
And
functioning
now this
further.
is an appeal. So if it's an appeal, that means the trial court had decreed in favor of the church. Is it?
Yes, my lord.
Yeah, you can come to a settlement. Ultimately, if the
Yes.
land has been made used for a good reason, maybe you could settle the matter.
Yes. It was freshly given in the year 2020, my lord.
Okay, 2020, 20
So
years.
still there is time.
You're willing to,
Yes, my lord.
you heard Mr. B. Laramena, learned counsel for the appellant, along with Mr. Lalbiakno Mahamte, learned counsel for respondent number
Number 1.
1. The learned counsels for both the parties submit that the parties are willing to make an attempt to come to an amicable settlement and pray that this matter may be referred to the District Legal Services Authority, who may place the matter before the next Lok Adalat, since both the parties are residing within Siha district, and it would be difficult for them to come down to Aiza if the matter is referred to the Lok Adalat, conducted by the High Court Legal Services Committee. Let's stop. On considering the submissions made by the learned counsels for both the parties, this court find it appropriate that this matter may be referred to the District Legal Services Authority, SIHA, who may in turn place the matter before the next Lok Adalat so that the parties can make an attempt to come to an amicable settlement. The registry to do the needful along with the High Court Legal Services Committee. Yes.
Much obliged.
Obliged.
Item 9.
Yes.
Look, I've received a copy of the affidavit filed by the respondent, and I need 2 weeks' time to file rejoinder affidavit, my lord. I may be granted 2 weeks' time.
No. Now there's an IA.
Yes, my lord.
So the IA is regarding what?
Regarding delay, my lord, in filing the appeal,
So written objection has been filed?
has been filed. It was
Then-
filed.
Then we can hear the matter.
I need to make some clarification, my lord, in the objection made by them.
So you can make it at the time of hearing. You want to file
Uh,
an additional, if you want to file an additional affidavit to the IA that has been filed, it's a different matter.
My
But
lord.
you don't have to reply to the written objection. It's ready for hearing.
My lord, in my opinion, it is required to make some clarification of the amendments made by them.
So you can make it verbally. Why does it have to be in writing? What sort of a this thing? Because
if that is the case, then-
this is an condonation application which is objected.
Huh.
Now what clarification that you can clarify
My
at the
lord,
time of, isn't it? 1,387 days. Now the clarification which you want to make, it was not highlighted in your application or what?
I have. However, in the written objection filed by them, they stated that I have done everything with full knowledge of the impugned heirship certificate.
So you deny that because that's what you're saying, isn't it, in your IA, that you didn't have knowledge.
My
So
lord.
they're saying you have knowledge. So we're going to see. Anyway, so we'll list it for some other day.
Right, my lord. No problem there.
I heard Mr. L.H. Lianshima, Learned Senior Counsel, for the applicant, assisted by Ms. Rodfali, Learned Counsel, and Mr. A.K. Roku, Learned Counsel for the opposite party / respondents. Full stop. It is seen that written objection has been filed by the respondents in view of the above matter may be heard and considered on, let's fix a date. Next week?
After a week, my lord.
Okay, on. Give a date, any date when both are convenient for both of you. After a week means on what, 26th? Tuesday,
26. No problem there,
On-
my lord.
26/8/2025.
My lord.
Yes.
Obliged.
Item 10.
Please, Your Lordship.
Yes.
But this is coming up for the first time.
Oh,
So
okay.
there's a delay of 112 days, 112 days.
112 days, okay. This is against an eviction? review
No, my
petition?
lord, this is against an order passing a review, allowing the review.
Okay. Heard Mr. Nalfakoma, learned counsel for the applicant, who has filed the instant application under Section 5 of the Limitation Act, 1963, for condonation of 112 days delay in filing the FAO against the order dated 20/01/2025, passed in review petition number 21 of 2022 in eviction suit number 15 of 2017, passed by the learned senior civil judge, within brackets, senior division, close bracket, dash Roman 2, comma, Aizawl district, Aizawl, full stop. Issue notice to the opposite party.
Respondent number 2. Respondent
Miss-
number 1 is the private respondent.
Okay, opposite parties, then full stop, then Mrs. Caroline K. Lalungoipui accepts notice on behalf of the state respondents number 2, full stop. Notice be issued to the private respondent number 1 through registered post within 3 working days, returnable by 3 weeks. List after.
Please, Your Lordship, may I make one small request, Your Lordship? If I may be allowed to take steps by way of Dusty as well, because she's a resident of Chaltlang, Aizawl. So,
No, so, okay.
Alternate- in
3
addition,
weeks,
in addition.
Okay, as well as through Dusty mode, wherein the learned counsel for the applicant is to file an affidavit to that effect. Then list after 3 weeks.
deeply obliged.
Hearing item 10.
Hope so.
Yes, my lord.